This case has to do with whether the Constitution requires states to recognize same-sex marriage if they recognize opposite-sex marriage.
Now, as you may know, same-sex marriage is a brand new phenomenon. As of the year 2000, no nation in the world had ever adopted same-sex marriage. No state in the United States had adopted same-sex marriage before 2003. And this case asks about whether the Constitution requires all 50 states to adopt this new form of marriage. And the state's argument is very straightforward. It's that the Constitution has always recognized that the people of the state have the authority to determine very basic questions about their family law. Marriage, divorce, adoption, these sorts of things. That's where the authority has always been in our country, and the Supreme Court recognized this as recently as 2 years ago in the Windsor case, that states have the authority to decide how to shape their basic marriage laws. And so the state's argument is, leave this issue with the people of the states.
There are 4 different reasons, at least, that the plaintiffs raised, arguing that it's a violation of the 14th Amendment for states to refuse to recognize same-sex marriage if they recognize opposite-sex marriage. One says that this is sex discrimination, that if you recognize marriages between men and women, but not recognize a marriage contracted by exactly the same sort of man, if he's marrying another man, that's sex discrimination and violates the Equal Protection Clause. Another argument is that this discriminates on the basis of sexual orientation and therefore violates the Equal Protection Clause for that reason. A third argument is that this fails even extremely minimal rational basis scrutiny that applies to virtually all laws. And a fourth argument is that this fails a kind of heightened rational basis scrutiny that applies to cases where the law in question is motivated by animus, in this case probably animus against gays and lesbians.
It's an issue on which people have very different opinions at a deep level of sort of philosophy, religion, morality, culture, about what marriage actually is and how we ought to define it. And so the way that our country is set up, the way the Constitution sets up our country, is that we don't take a top-down approach to these issues. We allow these issues to be debated in the individual states. It's what many people call the laboratories of democracy, so we can make sure that people have taken a considered view of this issue before making such a profound change to their social policies. So that's really the bedrock of the state's argument.